Hi friends, in this video, we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of Constitution, that too, in relation to matters challenging appointment to the heirs of the employees on their retirement or superannuation being violative of Articles 14 and 15 of Constitution. This video is prepared at the request of Advocate Naveen, who is practicing in Madras High Court. To know more about the compassionate appointment case, please watch this video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled, Ahmednagar Mahanagar Palika vs Ahmednagar Mahanagar Palika Kamgar Union, pronounced on 5th September 2022, the Supreme Court has held that appointment to the heirs of the employees on their retirement, superannuation is violative of Articles 14 and 15 of Constitution. The facts of the case would be that an industrial dispute was raised by the union with respect to the employment to be given to the heirs of the employees. By the award, the industrial court directed that the employees in Class 4 category, if they die before their retirement, if they become invalid, or if they retire, their heirs should be given appointment in their place. The direction was based on a settlement award between the employees union and the Mahanagar Palika, in which one of the demands by the union was that legal heirs of the employees must be employed on retirement. The awards passed by the Industrial Court were the subject matter of writ petitions before the Gujarat High Court. By the impugned judgment and order, the High Court dismissed those writ petitions. Being aggrieved, the original writ petitioner, who is the Ahmednagar Mahanagar Palika, through its commissioner, preferred the present appeals. The Supreme Court has held that in the present case, the Industrial Court directed the Mahanagar Palika or Municipal Corporation to give appointment to the heirs of the employees on their superannuation or retirement as per judgment and award passed in the year 1981, at the time when the Municipal Council was in existence. Thereafter, in the year 2003, the Municipal Council was converted to Municipal Corporation or Mahanagar Palika, and all the employees under Mahanagar Palika or Municipal Corporation are governed by the scheme or rules and regulations framed by the state, which does not provide for any appointment on compassionate grounds or the appointment to the heirs of the employees on their superannuation or retirement. Even otherwise, it is required to be noted that in reference, No. 1993, which was at the instance of Mahanagar Palika on the notice of change in respect of demand of employment to the heirs of the employer as per reference, No. 51 of 1979, the Industrial Court directed the appointment on compassionate grounds to the heirs of the deceased employees only. It was specifically observed by the Industrial Court that at the time of passing earlier award, the demand to provide the employment to the legal heirs of the employees on their retirement or superannuation was reasonable. However, in the present situation, the said demand does not appear to be good and reasonable. It was not open for the Industrial Court and or even the High Court to direct the Mahanagar Palika or Municipal Corporation to provide appointment to the heirs of the employees on their retirement or superannuation, relying upon the judgment and award passed by the Industrial Court in reference IT No. 51 of 1979. After the conversion of the Municipal Council to Municipal Corporation or Mahanagar Palika, the employees of the Mahanagar Palika or Municipal Corporation shall be governed by the scheme framed by the state and at par with the government employees, which does not provide for appointment on compassionate grounds to the heirs of the employees on their retirement and or superannuation. Even otherwise, such an appointment to the heirs of the employees on their retirement and or superannuation shall be contrary to the object and purpose of appointment on compassionate grounds and is hid by Article 14 of the Constitution. Compassionate appointment shall always be treated as an exception to the normal method of recruitment. The appointment on compassionate grounds is provided upon the death of an employee in harness without any kind of security whatsoever. The appointment on compassionate grounds is not automatic and shall be subject to the strict scrutiny of various parameters, including the financial position of the family, the economic dependence of the family upon the deceased employee, and the avocation of the other members of the family. No one can claim to have a vested right for appointment on compassionate grounds. Therefore, appointment on compassionate grounds cannot be extended to the heirs of the employees on their superannuation and or retirement. If such an appointment is permitted, in that case, outsiders shall never get an appointment, and only the heirs of the employees on their superannuation and or retirement shall get an appointment, and those who are the outsiders shall never get an opportunity to get an appointment, though they may be more meritorious and or well educated and or more qualified. Therefore, the submission on behalf of the respondent that the appointment is not on compassionate grounds, but the same be called as Varas Haq cannot be accepted. Even if the same be called as Varas Haq, the same is not supported by any scheme, and even the same also can be said to be violative of Article 14 as well as Article 15 of the Constitution of India. In view of the above, and for the reasons stated above, both the judgment and award passed by the Industrial Court, as well as the High Court in directing the Mahanagar Palika or Municipal Corporation to give appointment to the heirs of the employees on their superannuation and or retirement is unsustainable, and the same deserves to be quashed and set aside.